Hello and welcome to BYJU'S Exam Prep IAS. The big news for today is that the Supreme Court in a landmark judgment has expanded the scope of Article 19, saying that Article 19 is available to the citizens of India not just against the state but against the private individuals as well. In this episode of the big news, we'll be discussing what exactly will be the implications of this Supreme Court judgment, what is the point of view taken by the Supreme Court in giving this judgment, and also compare this with some of the other nations around the world. But before we do that, there's a very important announcement. After a long time, we are bringing back the Ask Us Anything live session on our YouTube. Tomorrow evening, 6th of Jan, from 7:30 to 9:30 p.m. live on our YouTube channel, you will have our prominent faculties interacting with all of you. We'll have Sarmat sir, Chetan sir, Sham sir, Mukesh sir, all of these will be taking all your questions live. You will be free to ask any question regarding your UPSC preparation, be it about your preparation, any doubts, anything that you want to ask these experts for these 2 hours tomorrow evening on our YouTube channel, and you will be given those answers. This is a golden opportunity. Do not miss this and join us live tomorrow on this session. Now, as I said, the big news for today is that the Supreme Court has expanded the scope of Article 19, saying that it is available not just against the state but against private individuals as well. Now, I'm very sure in Indian polity you would have read about the Part 3 of the Indian Constitution. Part 3 of the Constitution, which talks about fundamental rights. Now, essentially, what are fundamental rights? Fundamental rights are restrictions put on the state. The fundamental rights tell us what the state cannot do against you. For example, the state cannot discriminate on certain basis. The state cannot stop you from assembling. The state cannot stop you from practicing your religion, so on and so forth. Thus, most of the fundamental rights available to us in Part 3 are available against the state. However, there are certain fundamental rights against the action of the individuals as well. For example, right against untouchability is available against individuals as well. On the other hand, right against exploitation again available against private individuals as well. But most of the fundamental rights are available against state only. Let me give you one more example to expand upon this. Let's say a friend of yours or any person locks you up in a room, or let's say kidnaps you. Then this is a violation of your freedom of movement. You are not allowed to move around freely. You are being supposedly forcefully asked to stay inside a property. Then is it a violation of your fundamental rights? Not really. Why? Because if this was done by the state, if this was done by the police, if this was done by a government authority, then it would have been a violation of your fundamental rights. Since it was done by a private individual, it does not come in the category of violation of fundamental rights. However, now the Supreme Court has said Article number 19, more specifically, the freedom of expression and speech. This is available against private individuals as well and not just against the state. As you know, Article 19, freedom of speech and expression specifically, has been a very well debated right in the Supreme Court. The Supreme Court has said that this right would allow the citizens to seek its enforcement not just against the state but against individuals as well. Supreme Court has said fundamental right under Article 19 or 21 can be enforced even against people other than the state or its instrumentalities. It was a 5-judge bench. As you know, whenever there is a constitutional matter, we have a constitutional bench that comprises of at least 5 judges. This decision was taken by a 4:1 majority. The court said that the freedom of speech and expression cannot be curbed on any additional grounds other than those mentioned in the Article 19 itself. This is also a very important part of the judgment. As you know, the fundamental rights given to us are not absolute. Most of them can be curtailed for specific reasons. For example, if you go against public order, if you go against public morality, if you harm the national interests of the country, those are some of the reasons under which your right to freedom of speech and expression can be curtailed. As per the Supreme Court, curtailing of the fundamental rights also has to be based specifically upon the reasons given in the Constitution only, and no random reasons can be used by the state. The Supreme Court also said that the fundamental rights available to us are of utmost importance, and in those fundamental rights, Article 19 has a very special place. Article 19, as I said, is usually enforced against the state till now. It is not like other rights such as prohibition of untouchability, right against exploitation, that are available both against the state and the individuals. This interpretation now also puts an obligation on the government to ensure private entities also abide by the constitutional norms. So far, the government only had to put in line its own authorities, had to ensure that its own authorities do not violate this fundamental right. Now they would have to look into this from the side of the private individuals as well. Whenever we talk about the debate of fundamental rights, there are multiple cases that we might refer to. One very important case is the Puttaswamy case judgment of 2017. These 9 judges in the Puttaswamy case judgment specifically said that right to privacy is a right enforceable against other individuals as well, and thus cannot be elevated to status of a fundamental right against the state. Meaning that if you actually see, there's a pattern here. Year after year, in every few years, the government of India has been asked by the Supreme Court that more and more rights are available against private individuals as well. When the Constitution of India first began, it was assumed that most of the fundamental rights are only available against the state and not against the individual. But now, gradually, this perception seems to be changing. The Supreme Court of India also referred to foreign jurisdiction as well, while contrasting the American approach with that of the approach taken by Europe. In the famous New York Times versus Sullivan case, the US Supreme Court had found out that defamation law, as applied by the government against the New York Times, was inconsistent with the constitutional guarantee of freedom of speech and expression. Meaning that in the US, especially, the Supreme Court had said that their right to freedom of speech and expression is only available against the state and not against the individual. While the Indian Supreme Court seems to have taken a different kind of an approach in this matter. The reason why we are comparing this with the American approach is that, as you know, the fundamental rights concept in India has been derived and has been taken from the American Constitution. While in America it is called the Bill of Rights, in India we call the same concept as fundamental rights. And that is why it is important to note that our Supreme Court is now taking a path that is different from that of the American Supreme Court. This is where there is a concept of vertical versus the horizontal approach in terms of fundamental rights. For example, vertical approach of fundamental rights means these rights can be enforced only against the state, while horizontal approach means it can be enforced against other individuals as well. As we had discussed earlier, in terms of horizontal approach, you have the right against untouchability, since this is available against private individuals as well. Then we have Article 23, Article 24, that is right against exploitation, right against forced labor, right against exploitation, etc., which is available to us against private individuals as well. So they come under the category of horizontal rights. Vertical rights, on the other hand, are the ones which are available against the state only. For example, Article 14, Article 15, Article 16, even when you talk about articles related to your religious rights, Article 25 to 28, then we have Article 29, 30. These kind of fundamental rights in Part 3 of the Indian Constitution are still available only and only against the action of the state. So they still come under the category of the vertical rights. Even the right to life, as we discussed in the Puttaswamy case, has also now come under the horizontal right application as compared to the vertical application in India. This is it for today's big news. As you know, this Supreme Court judgment can have long-term implications on the control of fundamental rights and how this idea is now accepted and taken across the entire country. Do make sure that you remember and you follow this ongoing proceedings about the fundamental rights for the examination point of view, both in the prelims and in the mains examination. I hope that all of you by now have subscribed to our YouTube channel. If not, make sure that you do hit the subscribe button and also share such kind of videos with your fellow friends who are also preparing for the UPSC examination. Thank you so much for watching. Have a good day ahead.